Well, Sean, it is Friday Eve. But you know what? It doesn't feel like Friday Eve. Feels like a Monday. You know why? And the reason why is because they say that we're supposed to have 30 degrees on Friday. 30 degrees and rain.
Think that's gonna happen.
I don't know. And Rick is looking at me all quizzical. Hey,
I just find it interesting for this time of year to have that kind of weather.
hey, I'm not the meteorologist.
I know for a fact we're supposed to get rain, but for it to drop that low.
You know, we need to have a healthy snack bet, like celery and carrots.
This is from the woman who brought how many cakes this week?
Hey, here's the thing. You all asked for it, and it is springtime. How can you not have? You did. LaShawn, my mind is a steel trap. I remember you and Deputy Laura saying, since the judge has been on this diet thing, we don't get cakes.
Oh, absolutely.
Brought every
We did say
day.
That's true, that's true.
Thank you for not gaslighting me and admitting you said it.
Oh, we did.
All right, everyone, I'm going to call the docket. When I call the docket, stand and let me know you're here. If you don't answer the docket, I'm going to assume you're not here and a warrant may be issued for your arrest. In custody, we have Moses Wamuyu. Oh, are you? Thank you. Jamarian Greer. Elon Gonzalez.
Here.
Joseph Grant. Jose Velasquez. In custody, we have Michael Gonzalez, Mason Washington, Jose Cervantes, Alfred Rabago, Karen Garnica, Mason Washington, Felipe Reyes, Rico Silva in custody. Vashon, you know what that name reminds me of, right?
Who was that?
Do you remember they had that song called Rico Suave? You can always tell people's age by their name.
Absolutely.
Like when that song Brandy came out, anybody whose name is Brandy, I know they were born in the 70s. Cynthia Diano. Thank you. How do you pronounce your last name? Diano. Thank you. Ryan Westbrook. Ryan Jordan Westbrook. Sean, he broke the chain. We were doing so well with everyone being here. Javier Salazar. Javier Alejandro Salazar. Logan Martinez.
Here.
Frankie Lott.
Here.
Apollinar Rodriguez. Beverly Ramos.
Here, Your Honor.
Thank you. Gregory Pruneda, custody. Jose Flores. Jose Aaron Flores. Roman Flores. Roxana Gomez. And see, Rashawn, 90s. Diana Belmaris. Or Deanna Salinas Belmaris. Axel Ramirez.
First President Judge, will confirm.
Thank you. Hung Thom, custody. Michael Faz. Patrick Washington, custody. Fernando Trujillo. Deputy Laura, he's not here and I got my double L's correct.
Yes, you did.
Sarah Ashley Brown. Christopher Beltran is present. He's in custody. Matthew Jacob Salazar. Enrique Mendez. Thank you. Marissa Magana. Custody. Leon Small, Leon Aubrey Herman Small.
Judge, you put the U.S. Marshals picking up.
All right, thank you. Sydney Peterson, custody. Melvina Kane. Josan Guerra, custody. Ramsey Ibrahim.
That she is parking. I got to go text. I'll be honest.
All right, thank you. Shanna Taylor, custody. And Cortez Hook.
Matthew Salazar. I don't know if that was just for us to get status on the TAP
Yes.
evaluation.
Yes.
He was released from custody. The TAP evaluation indicated outpatient treatment.
All right, could you make sure that file is pulled for me, please? Ryan Westbrook. Ryan Jordan Westbrook. Javier Salazar. And that's not the sheriff.
Sure.
Apolinar Rodriguez. Jose Flores, Roman Flores, Diana Belmaris. Fernando Trujillo. Sarah Ashley Brown. Ramsey Ibrahim, which I know you say he's parking. All right, is there anyone present and your name was not called? What is your name? Timothy Evans. Did I miss someone? I'm sorry, which page?
MTR case.
All right,
Second row, sir. Mr. Evans, second row.
all right.
Yes, ma'am, we are.
I'm sorry, who?
Eddie Outlaw,
Eddie,
Outlaw,
all right. Do you know who your attorney is?
Mr. Guerrero.
Second row, no.
All right, just give us a moment. We'll look you up. Anyone else who's late? Yes, sir. Matthew Salazar? All right, thank you. And you, sir, what's your name? Javier Salazar. See, I told you it wasn't the sheriff.
Second row, sir.
Second row. All right, everyone. These are the rules of the court. Attorneys. Well, I've seen you all attorneys before. You all know the court's rules. Do I need to repeat them? All right, please do not violate the rules. Everyone else, if you don't see your attorney here, you have the court's permission to pick up the phone, go outside, call them. Because what I'm telling you, if your case is not resolved by 11:30 today because your attorney is not present, you're going to be recalled for tomorrow. And it's supposed to be raining tomorrow, and it's supposed to be 35 degrees, 35 to 40 degrees. Yes. Oh, just pick up the phone and call them. Yes. Please confirm. All right. Can I see the file on Beltran, please?
It's board.
Yes.
I was trying to figure out, because my arm thing had, 186.
Oh, just have a seat. I'm gonna see if it's on the docket. Yes. And then if you're not supposed to be here, if you're supposed to be in the 186, we will let them know that you were not late.
I appreciate it. That was.
You're welcome. So let me just look at you up.
So I was talking about that.
Okay.
That works. Thank you. Thank you for the odd. So I am shocked.
Everybody's. Faces.
All right, Mr. Outlaw is in the correct court. This is his cause number. So he has 3 cases. And just 1 second, Odyssey is circling around. All right, one of his cause numbers is 2025 CR 002531. And so if you could call his attorney, even though it says that his setting is April 15th, but if you could call his attorney. All right, Mr. Beltran, if you can come down, please. How you doing? Good morning. So your attorney, he's not here, but he filed a motion to withdraw your case. What I can tell you is usually attorneys will ask to withdraw from your case when they've concluded the trial portion of your case. And if there are any appellate issues, then usually an appellate attorney will be appointed to address that. Do you understand?
Kind of, I really didn't know why I was showing up.
Well, so you had a hearing on your case?
Mm.
And the hearing was on your case with regards to what credit you would receive?
Oh, yeah, for last
All right.
week.
Yes.
Okay.
And so your attorney has filed a motion to withdraw your case because he says that he's done everything that he's contractually agreed to do.
Okay,
All right, so do you have any objections to his withdrawing?
no, ma'am.
Okay,
Yes.
yes.
And Tony said he's running late.
Well, we don't need him now. All right. You don't have any objections?
No, ma'am.
All right, thank you.
All right, you have a blessed day.
Oh, you too.
Yes, ma'am.
So we've concluded with Mr. Beltran.
Thank you, Judge.
Yes.
You want me to tell Tony he doesn't need her here?
Sure.
You still here? Okay.
Logan Martinez.
He's done. I didn't feel like- He's in the council.
When you get a chance.
Number 9.
Let me call, can you pull his files and I'll talk to Mr. Outlaw and we'll see what he wants to do.
New case. Ready for it up there? Take it back. When we fresh.
Diana Belvares. Roman N. Flores.
I only have one of one.
Jose Aaron Flores. Apolinar Rodriguez. Logan Martinez. Ryan Westbrook. Cynthia Ciano. Timothy Allen Evans.
All right, Matthew Salazar, if you'll come forward, please.
Yes, ma'am.
All right, so on this case, we had a motion to revoke. And so there was a tap to be done in custody completion, upon completion of tap, he's to be released. What are the results of tap?
So the TAP recommends dual diagnosis outpatient program, monthly urinalysis, and documented sober support meetings, Judge. Upon speaking with Mr. Salazar this morning, he indicates that he has registered for the BIPP course. He had his initial evaluation completed. He did want to talk to you about that. And he also indicates that he was going to see about his attorney appearing today to try to get the no contact order adjusted.
All right, so you'll need to you'll need to contact your attorney for that.
Yeah, that's right. He says he didn't know about this, so I don't know if he's coming, but okay, that's,
Oh, well, I mean, he can set a hearing anytime he wishes to set a hearing.
yes, ma'am.
But this is what I want you to remember. The last time I saw you, you were in Orange, crying not to go to prison, right?
No.
So your minimum for this case is 10 years.
Oh.
I'm going to tell you what I tell a lot of people who come before me. If there's an issue, if you think you're going to use, if something's going up, you need to pick up the phone and call your probation office. Normally, all things considered, if somebody calls a probation officer and they have a drug issue and they say they think they're going to use, normally probation doesn't file a motion to revoke. They don't ask me to file a motion.
Yes, ma'am.
What they do is they'll send me notation saying defendant or the probationer is struggling with their sobriety. Then I will set it for a compliance. I will call you in and I will ask you what we can do to help you maintain your sobriety.
Yes, ma'am.
So when people are placed on probation, I want people to successfully complete it. Probation wants them to successfully complete it.
Yes, ma'am.
So from here on out, everything you do, you need to be thinking, is this something that could potentially result in me going to prison for 10 years? So the no contact order is still in place. If you want that changed or have the opportunity for having it changed, you're going to have to show me something.
Yes, ma'am.
And what I can tell you is I require that your attorney files a motion for that. If you no longer have an attorney, we'll still put it on the docket.
Yes, ma'am.
And probation will reach out to whoever the subject is of the no contact order. And I like to have them come in so we can discuss things.
My father said she's here, and when I went out to call my attorney, she's down the hall.
Okay, well,
But I just thought you may meet her, but. it's
no.
okay.
I mean, if everybody wants to have a hearing on it now, we can. Probation will let the family violence prosecutors know if this is a family violence case that you're asking that the no contact order will be changed. I'll get input from them, input from probation, of course, input for you if you want to give it. and also input from the person who's the subject of the no contact.
Do you think it's better to do, like, to tell the lawyer and then do that, or,
No, okay, so here's the thing. I really cannot give you that type of advice.
okay,
But what I can tell you is if you don't have an attorney, it's going to get set anyway, because probation is going to send me something saying that this person wants to have contact with whoever the subject of the no contact order is.
Yes, ma'am.
And you know what I'm going to say? What does the state say? What does probation think? And then I'm going to want to talk to the subject of the no contact
Yes,
order
ma'am.
as well.
okay, I'll just wait and ask Ms. Mita this.
Okay.
Okay, and I was gonna ask you this, I asked the lady from the bid class if she could email you, like all my stuff, so you can see that, like, she wrote what she says about me and everything. But she said it just goes to probation, but I wanted to know if I could give her your email, or you can send her something, so that way you can get all my updates and everything.
Oh, let me just tell you what ends up happening. Probation receives all that, and Officer Abrams receives all that,
Yes, ma'am.
and they always give it to me. So I'll know how people are doing
Okay.
in their classes.
And
And
I-
if there's an issue with the class, I always get an email about that.
Okay, yes, I just wanted you to know everything, because before, that's time on probation, she just stopped responding to me, and I got severe PTSD, anxiety, and I got scared.
Well, here's the thing.
But now I know, everything happens, she don't answer me, I'm just gonna come into your courtroom and sit there and try to see you, because I know that you'll help me out. I
Yes,
know that my anxiety and my PTSD caused me to just freeze, but I'm just coming here because I know that that's what I have to do.
yes,
You'll help me, yes, ma'am,
yes.
thank you.
All right, so if you have any other questions about anything, let us know. And if there's something probation can help you with, let them know.
Yes, ma'am.
If you feel they're not addressing it, you can always come in here. If I'm here, we'll address it and figure out what's going on.
Okay, yes, ma'am. And then another thing, I just wanted to let you know that you gave me before, 12, the NA,
Mhm.
and I've been doing it for over a year and I'm still going.
And how's that helping you?
It's good, very good.
Okay.
And then since I got out this last time, I started it all over again, but I've been going for a year already. It's gonna be, yeah, exactly a year in February, so a year and 2 months.
And the reason why I do that is sometimes it helps you when you know that there are other people who in the same position as
It
you
does.
are, and they're, trying to build their life back.
Yes, ma'am. And then when there's like, their experiences and their things and they're talking, it helps out a lot. And like, with my depression or being sad or something like that, it helps out a lot.
Well, I'm glad. And if you need anything, just let us know, okay?
Yes, ma'am. Thank you very much, Ms. Boyd.
All right, you're
Have a
welcome.
wonderful day.
You too.
Yes, ma'am.
That credit for time served. See how busy you are. But here.
Oh, do you have the paperwork on Mr. Outlaw? I'm going to. All right, thank you. All right, thank you. All right, Mr. Outlaw, if you'll come forward, please. Hello.
I love it.
All right, so I actually, on the system, it had your court date is April 15th. So we can do one or two things. One, if you want to, you can see if you can get in touch with your attorney. And we can see if we can get in touch with your attorney to take care of things now. That way you won't have to come back on April 15th.
I have no idea what he looks like. I've called his phone, he's not picking up, so.
Oh, well, if you don't mind, I'll have the court call him. And I'll also text him and see if he can make it. That way you won't have to come back on April 15th. Otherwise, you're gonna have to come back on
Yes,
April
ma'am.
15th.
Thank you.
All right, let me see what I can do.
Okay, thank you.
You're welcome.
Mr. Outlaw?
That's just for your information, mark down your own identity.
All right, thank you. Who's here on Ramsey Ibrahim?
Hey, Judge.
Are you ready to proceed?
We are finishing, it should be moments.
All right, thank you. And then Norma on Beltron, he needs an appellate counsel appointed.
But it's back.
Well, appreciate you.
And Norma, can you see if Renee Munoz is in the building?
Yes, it's supposed to be.
All right, thank you.
Judge,
Yes,
I'm ready on the street return.
all right. She stepped out to call.
Cool. Just letting you know that I'm ready.
All right, thank you. And state criminal trial division. Can you see if you can pull the files for Eddie Outlaw? Yes, I can give you one of the cause numbers. He has 3 cases. One of the cause numbers is 2025 CR 002534. Ryan Westbrook. Ryan Jordan Westbrook. Apolinar Rodriguez. Jose Aaron Flores. Roman Flores. Diana Balmares. Fernando Trujillo. And state, let me know when you're ready to proceed on Ramsey Ibrahim. And counsel, you can have your client approach.
Great. I usually let the deputy escort them around the room.
Oh, no, when they're in custody, and I call the docket, well, I call their case, they know to be here. Martin, one of your clients is here. He's not on the docket today. I think it's for the 15th. It's Eddie.
Oh, it was a pre-indictment setting. I'm not sure.
No, it's been indicted.
Oh, okay.
Yeah, so I'm asking him to bring the file down. I know you don't have any information, but Mr. Outlaw, this is your attorney here.
Okay.
I'll talk.
Okay, since he's set for April the 15th and you're here and he's here, I didn't want it to come back twice. Yes. Yes. Mhm. Okay. Hello. All right, how are you doing today?
To be honest.
I'm just,
That's fine.
all right. Now, we have docket sheets, but now they require us to put everything in Odyssey. So why does he have a warrant?
The warrant, the MTR.
Oh,
it
motion
was-
to revoke.
Yeah, it's motion to revoke. It was issued on March 28th. So it is less than a week old, Judge. So we got him into court as soon as we can. Thank
Okay,
you to
sure.
your wonderful coordinator. Getting this set so quick.
Awesome.
I think it makes a difference.
Oh, it does. I don't like for cases just to be out in the universe forever, because then when that happens, so much time elapses.
He knew he had a warrant. He knows why he's here. He's ready to address the court with that. And the quicker we get it done and the quicker he turns himself in, we figured that.
Logan Martinez?
I'm leaning on that one.
Okay.
And also my purple tie. The
Hey, I
one for
love the
LSU.
tie. Oh, LSU is out of the basketball tournament, but I always tell people they need to remember that the college players are teenagers. Don't lose your mind over a loss because they're already disappointed,
Yeah, the kids.
all you can do is do your best. Andrew, are you ready on Ramsey Ibrahim? All right, the court is calling 2024 CR 3624 State versus Ramsey Ibrahim. Can I have the parties announce for the record?
Andrew Harris, for the state.
And Andrew Fralick, Mr. Graham.
And are you Mr. Ibrahim?
Yes, ma'am, I am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Ma'am, I did.
Did you understand it?
Ma'am.
Are you the same Ramsey Ibrahim who was placed on deferred adjudication in 2024 CR 3624 for the offense of theft of service $2,500 to $30,000 on December 3rd, 2024 for a period of 3 years? Is that you?
Yes, ma'am, it is.
All right, state.
On or about the 10th day of February 2025 in Bear County, Texas, the defendant Ramsey Ibrahim did then and there fail to conduct himself in a proper and orderly manner when reporting to the supervision officer at the Bear County Community Supervision and Corrections Department in violation of condition number 4.
How do you plead to that? True or not true?
It's unfortunately true.
I'm sorry, I
it's
can't
true.
hear it.
It's true.
True. All right.
State waives the remaining violation allegations, Judge.
No objections.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
No, Judge.
State, what are you requesting?
Adjudicate guilt, revoke supervision, assess punishment of 2 years of confinement in the state jail facility.
And defense, what are you requesting?
Judge, we're requesting my client be given another opportunity and allowed to continue his probation. My client would like to address the court.
All right. And you say your client would?
He would like to address the
All
court.
right, can you raise your right hand? Do you solemnly swear or affirm the testimony? All right, if you all could whisper in the box, please, just whisper. All right, do you solemnly swear and affirm that the testimony you give will be the truth and nothing but the truth, so help you God? All right, you're whispering.
Yes, ma'am.
All right. You can lower your hand, state your name for the record.
Ramsey Ibrahim.
All right, defense.
Ramsey?
So after the incident happened, I came to court and I was found, guilty of the,
You pled no contest.
Pled no
and you were
contest.
placed on probation.
well, after that incident, I lost my job and then I've been seeing a therapist, a psychiatrist. Before all of this, I've had pretty severe depression and anxiety.
Judge, may I talk to my client for just a moment?
There's no justifying the attitude that I had through the things that I
All right,
said.
so what happened?
I lashed out by
How?
by just not. I used a lot of. I was cursing, but not at the officer, at the situation. I was just
Any
venting.
objections to the court review of the court summary?
If my client could be allowed to apologize before the court reviews the court summary?
No, I want to review the court summary because then I can have
I know.
more information about what's going on because he's not telling me everything.
I wrote an email one night. I wrote an email.
No. Any objections to the court review and the court summary?
No, Your Honor.
No,
I approached Judge, and you
Yes.
don't already have a copy.
It's sent by email, and what I will tell attorneys, I receive emails from Officer Abrams of TAP evaluations, the PSIs, but I don't read them or open them until I ask both parties if they have any objections to my reviewing it, because I know it's hearsay. So since defense counsel doesn't have any objections, I am going to open the court summary and let me read it, and then I'll let you continue. All right.
Is my client to be allowed to continue?
Yes.
First and foremost, I apologize so much, so sincerely for the outrageous stuff that I said. I was in a really low spot, and
But according to the court summary, and let me explain something to everybody. I understand that people have, sometimes they're angry at their situation. Sometimes they don't want to accept responsibility for their situation. I understand that, right? So, but according to the court summary, they're saying that this isn't the first time that they've had an issue with you.
and that's basically the only notable time that we're.
Well, no, not only notable time. I'm just telling you what they say. This is what it says. It says, this is not an isolated incident. He has consistently exhibited defiance towards his probation officer and field officers, refusing to comply with basic probation requirements and making it clear that he has no intention of changing his behavior. So that's before the letter. That's what that seems to imply to me, that this isn't the first time. So they have the letter. And they're saying that when field visits are conducted, it's the same,
Man,
similar things.
okay, so like again, I'm very, very sorry. And this won't happen again, but as far as the field visits were concerned, I was thrown into agitation when the officer came.
No,
Hold on.
it's fine. I'm just trying to figure out what's
I
happening.
understand, Judge. What my client is saying is that before this motion to revoke was filed, before he came and talked to me, I don't think he really had a full understanding of what he was looking at and what the court may end up doing today. After I talked to him and after I really informed him of what he was looking at and what the court might do, and after hearing Mr. Edelman say what they're requesting,
Mhm.
I think you can see my client's attitude has shifted.
Mhm.
I want what Ramsey was talking about, Judge, is he had a bad attitude. He just pled true to a condition that I've kind of never seen on an NCR before, of just not fail to report, not the rest of it, but fail to conduct himself in a properly and orderly manner. He's pled true to that. He's accepted responsibility for that, and he has promised that he's going to make a change. I think that since I have had the opportunity to talk to him about realistically what he's looking at, should he not, in the rest of his 3 years of probation and the conviction and the 2 years day for day,
Mhm.
that his attitude has shifted in a remarkable way. He's willing to apologize to each one of those officers if he's offended, apologize to the court, apologize to the prosecutor if need be. I just want to make sure that the court understands and sees his change in attitude. That's why we're here, is his attitude is poor. Was poor.
I sincerely mean my apology.
All right, so my question is, I'm back to my question. So it's stated in the court summary, this is not an isolated incident. So when they say it's not an isolated incident, I'm taking that to mean the email that you sent, right? So let's not even talk about the email. So they're saying you have consistently exhibited defiance towards his probation officer and field officers. And the field officers are the people that go out to see you because I require that their field visits. And actually, your probation, I don't do cookie cutter probations. Your attorney will tell you that.
That's true.
Your probation that I gave to you in the big scheme of things, the conditions that I've given people, it wasn't that much. You didn't even have restitution to pay because I guess people received their items,
Sure.
but you were only 3 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, field visits one time for 3 months, and 200 hours of community service restitution in the theft course. That's all.
Just a second.
Yes.
Sorry, Judge. What my client is concerned about is that yesterday
Mhm.
he made a payment to pay off his community service hours.
Okay. Oh, no, that's fine.
Again, that's what he's trying to say. And you're looking for a job
And the restitution.
you paid the restitution in full before the plea judge.
Yes.
That was part of this, as plea bargain, he did pay the restitution up
Alright.
front. That's why it's not a probation
Okay.
condition. So, and again, in this past week, I want to make sure I got it. He has registered for the theft class. He has paid his community service hours off in full. He has reported here today. He has apologized for his behavior. I think that in the past week since this MTR was issued, he's gotten the message.
All right. And how old are you?
40.
40? Okay. All right. Is there anything else?
I want to give you one opportunity, just sure what we talked about. Go ahead and address the court.
Yes, I'd like just to reiterate, once more that, I mean, I am honestly sorry for having offended everyone there. I've, spoken ill of.
Mhm.
And the attitude, I mean, you're gonna see a complete difference of everything going forward. If you just please give consideration to allowing me to just get back on track, and I'll make good on the conditions. I absolutely will. I was just frustrated with the situation, and I lashed out.
All right. So let me explain something to you. So now let's get to the letter that you wrote. It takes a lot to send an email to somebody. And what you said
Yeah.
is I'm literally cast aside and blacklisted on the same level as effing rapists, pedophiles, and effing real felons. You're in felony court. Sometimes people think that, oh, I'm not like other people who are charged with crimes. And then you say, I hope a prison convict breaks out, rampage rapes all the aforementioned, and give them AIDS. It takes a lot of anger to write that and to send it.
So after I got this recent denial from the perspective
Mm-mm.
And that was sent on March 26, 2025.
there's no justifying that level of right? I mean, I'm embarrassed to even having it here, and it was at my lowest point, and there's no BS. I was angry.
Oh, State, you may continue, your excuse, you may continue to confer.
Yes, but I mean, I'm telling you, that was at a point of just ultimate low. And
Excuses.
there's not an excuse. There's just a sincere regret.
Judge, my client would like the opportunity, if he's allowed to continue his probation, to apologize individually to each one of those people. If you would like to make that a condition, that would be great. I know it's usually outside of what we do, but it wouldn't be unusual for you to allow him to apologize.
Mhm.
And I do apologize to you.
All right, I understand. And I understand that people are angry sometime. All right.
Judge, we would ask also, as an additional condition, if we could add a cognitive behavior course or an MRT course to those that may assist him.
I just started seeing a therapist and talking to a psychiatrist.
I think that I think the court can see that he clearly has reading and hearing what he wrote. I think that the court can see his sincere level of apology and wanting another chance.
All right, and probation, what are you recommending?
Judge. The court summary indicates revocation. Mr. Abraham has only been on probation since December, and although
He did sign his letter, yours truly. I think there should have been another thing other than yours truly, maybe with regards or something.
agreed, Judge. The court summary says revocation. I would say that he could benefit from some courses like the cognitive behavior course and more recognition therapy. There has been, I know the court reviewed the court summary, and you can see that there was some positive urinalysis that were waived by the state. However, he did produce a copy of his prescriptions. No prescription for alcohol, so that is something that we would have to really hone in on. But as far as the other positives for actual substances, I do have prescriptions for those. And he did provide the receipt for his community service hours. The community service hours were paid to Feeding America, so I would ask the court for taking that into consideration. Other than that, Judge, that's all I have.
So are you asking for revocation? I understand the officers requesting revocation, correct?
That is correct.
All right, thank you.
And if I could, Judge, I understand why the officer would recommend that after reading those emails. Again, I would ask for the courses. I would ask that the court allow my client to issue a full apology, email, handwritten, or in person, however the court wants to do that. If my client is allowed to apologize,
I'll do all of the above.
he is taking this quite seriously now after our conversation. Whatever the court would like to do, we'd ask that he be continued.
All right, this is what the court is going to do. The court is finding violation of condition number 4 true. The court is going to find you guilty. The court is going to revoke, sentence you to 2 years in the state jail facility, give you credit for any time served, and the court will retain jurisdiction.
Thank you.
And you can explain to your client what that means. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
All right. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Because this is not a plea bargain agreement, we do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision or deferred adjudication. Do you understand? And you can explain that to him, counsel.
Thank you for that.
You're welcome.
Fix the camera, Judge.
Like Mr. Peterson, I want to get the dance.
Rico Silva. Is he in the box?
No, Judge.
All right, he's in custody, correct?
Yes, Judge, you need him?
Yes. All right, and can you also bring up Felipe Reyes? Who's here on Roman Flores?
Adam, the first, you can step out, Judge.
And so.
They're not ready.
Yes.
All right, who is here on Shauna Taylor? It says Shauna Taylor.
Yes, Judge, same person.
All right, thank you.
Our position.
Hello. All right, the court is calling 2024 CR 6075 State versus Nita Michelle Taylor. Could I have parties announced for the record? State,
Andrew Harris, Edelman.
defense,
Thomas Beck for defense.
and are you Nita Taylor?
Yes, I am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, I did.
Are you the same Nita Michelle Taylor who was placed on community supervision for the offense of theft of property less than $1,500, two or more previous convictions on January 7, 2025 for a term of 5 years? Is that
Yes,
you?
ma'am.
State?
On or about the eighth day of March 5 in Bear County, Texas, the defendant Nita Michelle Taylor committed the offense of theft in violation of condition number 1.
How do you plead to that? True or not true? True?
True.
It waives the remaining violation of
Any objections to the waivers?
No, Judge.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion? Just one moment. All right, if you all could step back, the judgment on this case is incorrect, so that there needs to be an amendment to the judgment because this is a third-degree felony. It shouldn't take that long.
What needs to be done?
Oh, the judgment needs to be amended because the judgment has this listed as a state jail felony, but it actually is a third degree. So it won't take that long to do it. Yeah. This should be listed as a third degree felony and it's listed on here as a state jail felony. Apollinar Rodriguez.
Adam's not here yet.
All right, so everyone. Don't believe that, until the attorney shows. Logan Martinez. Who's the attorney for Logan Martinez? All right, come forward. Let me see. Oh, Vashawn did that.
Yes, she did.
All right, counsel, where are we on discovery?
Judge, I think we're okay, but a preliminary question is whether or not Mr. Martinez needs to be reassigned to another court with co-defendants. The state and I have been discussing that for a while. We've sorted out who the co-defendants are, where they're set, who's got the JNs, all those questions.
Okay.
But Ashley, who's been working with her supervisors about getting approval, hasn't quite gotten that approval yet.
What approval to transfer this?
Well, to agree that they're co-defendants, I think.
Your Honor, it's not completely clear from the facts of the case that they would be considered co-defendants, and so although that may be an opinion, I still need to get approval for that.
All right, and so when is that approval going to happen?
I'm trying to.
All right. Then on this case, you all still need to make sure that he's receiving his discovery. Ms. Ferguson, recall this. Are you available for April 14th?
I think so, Judge.
All right.
If for some reason we get a resolution of that before, can we approach the court about the transfer business?
Yes, and is he in school?
He's over 18, Judge.
Oh, okay. He looks young.
He does, but he graduated.
I just got an yes, I graduated.
All right. So Norma, recall this for April 14th.
Oh.
All right.
Thank you, Judge.
Is there anything else?
That's it.
All right. Once you sign the reset form, you excuse. Thank you for dressing appropriately for court.
Thank you.
Okay, yeah, I'll get it done. You're welcome.
Yeah.
Mason, Washington. Hello, you're on this side. How's everything going?
Good. How are you doing, Judge?
Oh, I cannot complain. Hello. Hi. So where are we on CPS records? Yes.
We have the CPS record in our custody. I just need to run upstairs to have our paralegal make a copy for defense on that, and then probably provide it for this afternoon.
Okay. All right, and then last time there were some audio files.
Yes, Your Honor. There were no body cam videos. We've received, I believe we've received everything we need in evidence as far as that goes, Your Honor. I have conferred with Ms. Jones with a potential counter offer. She is going to discuss that with complainants and let me know. Your Honor, I intended to approach the court for an expert to resolve this case, but I would ask if we could have a maybe 2-week rate reset to see if we could come to an agreement, Your Honor, and if not, if I could approach the court on my expert to appoint, on my motion for funds for an expert, Your Honor. So all the discovery in the case in chief we have, but if the court were to grant my motion to appoint an expert, he is asking for some things from the lab to look over, Judge. And so I would ask to approach on that at that time if negotiations fall through, Judge.
Well, I'll go ahead and sign the request for an expert. And then if it turns out you don't need the expert, then you won't need the expert. There are some things that she is requesting as far as discovery for her expert. So if you all can review that way, if her expert needs it. And then
And Your Honor, I do have this fee schedule. I'm not sure how much funds the court is willing to give upfront, Your Honor, if you just.
what are you requesting up front?
So he's requesting 2750 for the case review, Judge. And then if this does have to go to trial, it would be an additional fee. I do have his CV and his fee schedule for the court to review.
Oh, I don't need it.
Okay, thank you.
There you go. All right, and then the other thing we have is I had notation that there was something involving a runaway case.
Yes, Your Honor, upon further going into the discovery, Judge, we do have a report, and I think that's all that we need at this time as far as that case, Judge.
All right, then what I can do is I can recall you, 2 weeks deadline is the week of April 21st.
That works for the bench, Judge.
Y'all want to come back on April 24th?
Yes, Judge, that's.
All right, so it will be recalled back for April 24th. Is there anything else?
No, Your Honor.
Any questions from you, sir?
Just want another chance in life, that's all.
Okay. All right, thank you so much.
Thank you, Judge.
That's my approach.
All right, thank you.
Can I approach Judge?
Just give me a moment. I understand you're ready. Just give me a second. They've amended everything, so.
I don't think anything's been done.
Yes.
Oh, okay, but she was just asking, because she was here for the public.
All right.
Gonzalez is just. I just have a small thing to say, Judge.
All right, just give me a moment. I need to put this in the system.
Oh.
Not really a good thing.
Yes. Yes.
Judge, I'm not sure what's going on.
Oh, the judgment was incorrect. So it's a third degree felony. It's not a state jail felony. It was listed incorrectly on the judgment. So they've corrected the judgment and we cannot proceed unless the judgment is correct.
Okay, can I be excused if we're not gonna have the hearing or?
We are going to have a hearing. What I'm telling you is they had to
No, I got you.
correct the judgment.
So they
Yes.
corrected it.
Yes.
Okay, good.
Okay. No problem.
Because Judge, I have other courts to go to. I know you're extremely busy.
Yeah, I mean, I understand everybody's busy. I mean, it takes a while for them to correct the judgment. They're telling me that they've corrected the judgment. I just finished this case, so I will
Thank you.
call your case.
Everything's perfect.
Thank you.
Appreciate it, Judge.
Uh-huh. All right, court is calling 2024 CR 6075 State versus Nita Taylor. Could I have parties re-announce?
Andrew Harris, State.
Thomas Beckford, defendants.
Hi, and are you Miss Taylor? All right, so Miss Taylor, the judgment was incorrect in your case. The judgment showed that this was a state jail felony. All of your plea paperwork shows that this is not a state jail felony. So I wanted to make sure that that judgment was corrected. All right. So the judgment has been changed to reflect that this is a third degree felony. Do you understand?
Yes.
All right, so you entered a plea of true to a violation of condition number 1. Do you understand that by pleading true to violation of condition number 1, the court could revoke your community supervision and sentence you up to 6 years in the prison? Did you understand?
Yes.
All right, knowing that, do you still wish to plead true to violation of condition number 1? All right, the court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Judge, revoke supervision, reform the judgment, and sentence to 4 years of confinement.
TIC.
And TIC, the 2 new number 1s.
And these are the 2 cases that are within the motion to revoke?
Yes, Judge, 2025 PF 08971 and 2025 PF 08972.
I'm sorry, 2025 PF 08.
971 and 972.
All right. Are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal? All right, the court is going to grant the motion. The court is going to revoke, sentence you to 4 years in the prison, taking consideration 2025 PF 08971 and 2025 PF 08972. Give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yeah.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you.
Thank you.
You're welcome.
Oh, thank you, Judge.
Sure,
I've got a little impatient, so.
no problem. You may be excused. All right, thank you.
I don't know if they're gonna be around, it probably shouldn't take more than an hour to
All right, thank you.
Oh.
One say. Thank you.
When you start up.
I'm sorry.
Felipe Reyes, if you can come down, please. Good morning.
Morning, how you doing today?
All right, how are you doing today?
I'm doing great.
They say we were supposed to have cold weather on Friday. I know they keep it cold at
My
the
mom
gym.
told me that they had like a storm the other day.
Yes, and it's supposed to be more heavy rain.
For real.
Yes, but I didn't want you sent back to the jail without at least coming into court. Your attorney is asking that your case be reset for Monday. So we're going to recall you for Monday. That's still going to be your plea deadline date. So on that date, you'll need to let the court know whether or not you've reached an agreement. If an agreement is not reached, your next court setting will be your jury trial date. Do you understand?
Yeah.
Do you have any questions?
So, no.
All right, your attorney said he's going to come visit you, all right?
Okay.
All right,
Thank
thank
you.
you. Have a good one.
You too.
Judge, may I approach?
Yes,
For Ms. Taylor.
all right, thank you.
What? Yes. Thank you, Judge.
You're welcome. Deputy Laura Reyes can go back.
If you're wanting a contact order to do Oh, okay.
All right, Rico Silva, if you'll come down, please.
So she needs me to.
Hello. Hi, I did not want you sent back without being brought into court. So this is what's happening. Your attorney is also a magistrate judge in El Paso. So we're going to reschedule your case, and your case is going to be rescheduled for April 23rd because that's the date that he's available. Do you have any questions?
No.
All right, and have you had contact with your attorney? All All right, is your attorney, is this attorney appointed?
Yes, ma'am.
All right, so then this is what we'll do. If you'll have a seat, we'll see if we can get a attorney to, I mean, a magistrate, I'm sorry, a managed assigned counsel to come down and speak with you, okay? All right, who's here from managed assigned counsel?
She's on the first row, Jim. Max.
Hello. Hi, good morning. All right, we have this client here. He says he hasn't seen his attorney. This is his attorney's information. His name is Rico Silva. And then we have another person. They were not brought over, but they, yes.
Yeah.
But they have mental health issues. And I don't know if their attorney has had contact with him or not. We've had a couple of no-shows for court.
I know she was out. She did email and said that she was sick. I was aware of that. Could we ask for a reset on that? I'm
Okay.
unsure if she's in the.
All right, so when would you like that recall on Polk? Because my concern is, it appears that he needs a mental health evaluation, but I didn't want to step on her toes or interfere with their relationship by asking for one, even though legally I can. But I don't want him to deteriorate further in the jail. So what date?
That's correct. We do have our mental health team that's able to do the evaluation with him as soon as possible. So when I get back to the office, I'll make sure.
All right, so then what I'll do,
Can we do a week out from today?
sure, you want to do it the week of the 14th?
Okay, let's do it.
What is it, the best day for you? I have available the 14th, the 15th, or 17th. Monday, Tuesday, or Thursday.
Let's do the Thursday. Your Honor.
All right, so that'll be April 17th. Could I see the file on Polk, please? And then you can just approach me whenever you're ready on Mr. Silva.
Yes, Your Honor.
All right, thank you so much.
Thank you. One moment, okay? And then I'm gonna talk to.
Should I ask? That's you, Arthur. No, I don't think there was anything, there was just a clear, something to report to. There was just something that I had to do. Yeah. No, yeah, we made it, yeah. No. Mr. Meadows? You looking for the first?
Yes.
We have it. I'll give you a copy.
Is this lady, Maris Salinas? Calling her name, both names. You were telling me. Okay, thank you, that's all. You said, no, you're just telling me to check it.
No. So I'll put it there so you can let the judge know.
Okay, I'll have to check that. I heard this week before it started trial, so I'll be back.
Okay.
I think she
Yeah,
should.
start from-
Oh, I thought it was that fine.
Yeah, but you need to-
Yeah, no.
Thank you, so if they want.
I could definitely do a plea.
Yeah, you'll tell them whatever they want for that because you don't mind. Not for the sure.
No.
Well, I'm just reading there. And so we can give you one sign.
Salinas, Alvarez, one more time. Because I'll come back and I need to go clean tonight.
Sure.
All
All right, no problem. Sydney Peterson? Hello,
Morning, Judge.
good morning. How's life treating you?
Oh, it's treating me good.
Oh, the only thing, good morning. The only thing better than that is it's treating you great. All right, so we're here for sentencing. So he entered a plea of true to violation of condition number 2 on March 18th.
Yes, ma'am.
All right, court is calling 2023 CR 1041 State versus Sydney Lee Peterson. Can I have parties announced for the record? State? Defense?
Gary Chirek for the defendant.
All right, and are you Mr. Peterson?
Yes, ma'am.
All right, on March 18th, you entered a plea of true to violation of condition number 2. The court found that it was true. The state waived all other allegations without objection. And so we're here today for sentencing because I believe parties wanted to present evidence or some testimony for the court. Is that correct?
I think so, Judge, and I thought you wanted to take it into consideration what you wanted to do with him.
Yes, that as well. So are there any witnesses?
There are none, Judge, unless you want to say something, Mr. Peterson.
Yes, I just want to apologize for my actions, and I want to apologize to my daughter Max, to Stephanie, Lizette, and Robert for what happened that day. I need help, Your Honor, and I pray that you can give me the help I need. I have a drug and alcohol problem, and I've been dealing with this for the last 8 years of my life.
All right. And when you say what you did, what did you do?
Everything that happened that night, man,
And what is that?
I don't remember.
All right, Ms. Abrams, do you have a court summary on Sydney Lee Peterson?
Judge? If you give me a moment.
Yes. And state, what were you requesting?
Judge, if I could just talk.
Sure. And what happened with the number 1? Is that still pending?
I think it's still hanging out there. I don't know where
Yeah.
it's going.
All right, let's do this. Let's step back so you all can confer on the new number 1.
All right.
All right, they're going to confer on the number 1 in the motion. All right, thank you.
Court summary?
Yes, please.
I had it written down as a sentencing disposition. It was seen a couple of weeks ago when I was in here. So I didn't,
Thank you.
thank you.
Enrique Mendez. Hello. Hi, how are you doing?
I'm doing good today.
All right, so I received notice saying that you needed to travel in order for a medical.
Yes, I need to have two fruits from my molars removal because my cups, they broke down.
All right.
I've been in pain because, every time I get something sweet or hot.
Oh, no, I understand about tooth pain. It has to be done. Who's the prosecutor on this? It's on Enrique Mendez.
What's the charge, Judge?
It is indecent exposure. So he wants to travel to have medical work done on his tooth.
Yes.
He will go and come back the same day. Do you have any objections?
We do, just given the facts of the case and given where the exposures took place, there were multiple at places of business, and so the state would object based on that. However, we understand that the court may grant given the reason for it.
All right, here's my thing. With regards to tooth issues, it's the court's understanding. I'm not a medical doctor, but I do know, based upon what you're telling me, based upon what's in the report, that if that's not taken care of, people have died when they have infections in the tooth. It goes to the brain, it goes throughout the body. And since he is leaving and returning the same day, and the report I've seen from the court is that there have been no issues with you while you've been on probation. So I'm gonna allow you to travel to on Saturday, April 5th, to get the medical procedure done and come back. This is what you're gonna need to provide to the court when you come back, or
Yes.
provide to probation.
Yes.
You're gonna have to provide notes from the doctor that that's actually where you were.
Mhm.
And if they place you on medication, which they probably will, you need to provide those prescriptions to your probation officer. Do you understand?
Yeah.
Probation, is there anything else that needs to be added?
No, Judge. The year analysis.
All right, it'll be a UA upon return, but
Yes.
yes, but you'll need to make sure that you give them your medication so they'll know.
Okay.
All right, is there anything else you need?
No.
All right, continue. You're welcome. Continue following all the rules and regulations, all right?
Sure. I will.
All right, and good luck on the surgery.
Thank
you.
you very much. God bless.
You're welcome. Thank you. Frankie Lott. Good morning. Hello.
He just needs a moment, Judge. Good morning.
Sure, no problem. All right, so where are we on this case? I know the last time there was an agreed order for him to travel. So the court has not received any negative reports from that time.
Very good. I think this is just our first indicted setting, Judge. So we've conferred this morning and
Okay, I don't have, they still have it listed on my form as not indicted. So you all have conferred?
Yes, Your Honor, the state has relayed our recommendation to the defense.
And counsel, do you have all discovery?
I think so, Judge. There was some setbacks with Mr. Lott's health, so I just need to go through discovery with him and I'd like to just reset it to do that.
All right, so what I'm gonna do is I'm gonna give you all a plea deadline date. And I will give you a plea deadline date in May. What's a good date for you, counsel? I can do it the week of May 19th if you want, or I can do it early May.
The 16th, I'll be back on the 27th.
All right, counsel, do you want to put this on the 29th?
That'd be great, Judge.
All right, so this plea deadline will be May 29th. Once you sign the reset form, you are excused. Thank you for
Ron.
dressing appropriately for court.
Yes,
You can head it after.
Already made
it. The reset. Go back to your sister. Thank you.
Just gonna clean on this one, just miss that one. But I need the form? Yes. Okay. Understood.
Thank you.
We don't sign it right now?
Yes. All right, Elon Gonzalez.
Great, Judge.
Hello.
Hey.
The easiest thing to do all day.
All right.
Don't want to fall and hit the.
Okay.
And the bailiff's.
Okay.
Okay. You okay? You said.
Oh, no, there's no need to apologize. Medical will be on their way, okay?
Yes, ma'am. Judge, we're gonna start clearing out everybody.
All right.
Yes.
All right, come on, guys.
There's the other courtroom.
Hey, Axel, wait outside.
So if you all will wait outside because we need to have medical come in.
Oh, nice. Jason.
And to the persons in the box, they're going to bring you back. We just have to have medical come in.
Jason.
Yes.
On Mr. Outlaw, they've had some difficulty locating the files. Eddie Outlaw.
Yes.
Um,
I'll give you a reset. I just didn't want him to have to come back again on April 15th.
okay.
All right, so we're gonna give you a reset.
He's in the hallway. Do you want me to bring him back in here?
Oh, they're moving this gentleman out. Norma, Eddie Outlaw, reset that for May 5th for discovery.
Eddie Outlaw.
Sorry.
So.
And then you can call him again.
State Eddie Outlaw is gonna be reset for May 5th. Oh. All right, so they're gonna get ready to bring your clients back out.
Yes. They should have to hold them in the back. Because of what happened. They'll be there.
All right.
The biggest spot downstairs. Everybody coming out again then.
All right, thank you. Yeah. Do you see what page Eddie Outlaw is on?
Judge, he wasn't not on the docket because he wasn't set till April 17th or 15th.
15.
All right, so May 5th, okay?
Yes. Thank you, Jeff.
Thank you. So Deputy Laura, you want to let every,
Yes, they're coming out.
all right, thank you. Who is here? I'm Elon Gonzalez.
Bexar, one second.
Here, Apollinar Rodriguez.
That was mental sentence is not presence.
Rico Silva. All right. Oh, no, just have a seat. So Mr. Statson is going to come speak to you. And it's the court's understanding that you're requesting a new attorney. Is that correct? Yes or no? All right. So an attorney is going to be appointed to represent you. All right. And Mr. Statson, just let me know when you're ready to proceed on that.
Yes, Judge. I'll confer with Megan. She can let me know that it'll be in the time.
All right. Thank you.
I have a plea of my own I'm working on.
All right. Thank you. Diana Belmaris.
Yeah, we are ready.
Yes.
Gregory Pranita. Hello.
Good morning, Judge.
Good morning. One of my friends called me and she said her daughter is going to be cooking a turkey today. She's like, so there you go. All right, so where are we on discovery?
We're fine on discovery, Judge.
Okay.
There's been an offer made. And Gregory would like an opportunity to go back to the jail and reach out to certain members of the family and stuff, but contemplating it. There's other issues involved.
All right, how old are you?
Therefore,
All right, so I'm going to recall this back. Counsel, are you available April 8th?
it's next week, Judge, next
Yes.
Thursday or Thursday.
Thursday.
My son has a track meet Wednesday.
Oh, you got it.
Wednesday or Thursday, so
Do you want to recall it on the 6th? That's a Tuesday.
let's stick with Thursday, Judge, and then I'll get back to you when we move it up, but I think the track meet's on Wednesday, but
All right, so here's the thing. Usually with track meets and students, you have to have time to travel. So who knows, maybe you want to go up on the 6th. I'll recall it back on April 5th. I'll recall you back for Monday for your plea deadline date.
this Monday?
Yes.
Okay.
All right, is there anything else?
No, Your Honor.
All right, we'll see you back on April 5th.
Thank you, Judge.
Thank you.
You're doing real well. There's a relay team opportunity.
That's awesome. So which relays is he?
The one, he anchoring the 4x1 and the 4x2.
Oh, wow.
He had a really good meet. Tuesday. But it looks like he may get to go to state this year. But he wants to go as an individual in the 100.
Oh, that'd be awesome. Keep me posted.
Thank you, Judge.
All right, have a good one. All right, are you already on Mr. Churek's client? Sure. All right, Axel Ramirez. And where is,
We received an offer on that, Judge. I'd just like a couple of weeks so I can look at discovery with them, to go over the offer.
all right, so you want a plea deadline date?
Yes, ma'am.
When do you want it for?
If we can do 30 days. I'm gonna be here on the 6th. We come back
May
to that
6th?
7th? Yes, ma'am.
All right, so we'll do your plea deadline date, Norma, for May 6th. Thank you for dressing appropriately for court. Once you sign the reset form, you will be excused.
Thank you, Judge.
All right, thank you. Robert, I want to ask your client, where is the name Axel coming from?
I have
You know
a feeling.
You know, they had an Axel on, in the middle.
I have a feeling.
Ah,
Yeah.
Mr. Ramirez, we have a question. And your attorney has given me some ideas. So your name Axel, where did that come from?
I guess my mom was a fan of Axl Rose.
Okay. Thank you so much. I was thinking they had an Axel on in the middle. One of the children's name was Axel, but Axl Rose, okay.
Oh, no, Judge, it's gotta be.
Yeah. Mr. Ramirez, and thank you so much for helping the gentleman.
For all the appearance or only thing that they're over the appearance, I think should have to print out, but for everybody we have to print. Jason, yeah. Oh,
Jose Flores. State Flores is going to be recalled for April 7th. And he currently has a warrant for this case. Apolinar Rodriguez?
Mr. Procedural.
Yes.
Judge, we've made multiple attempts to contact him. We had mentioned that he was homeless, but we reached out to his bondsman as well. The number we got from that one said it was disconnected.
Just 1 second. Court is calling 2025 CR 001769 State versus Apolinar Rodriguez. Can I have parties announced?
Andrew Harris Edelman for the state.
Attorney Bill Simmons for defense.
All right, this hearing was called at 9 a.m. The court announced the defendant's name. The defendant did not respond. Defense, have you had any contact?
We have not had contact with him, Judge. Since this morning, we reached out to him yesterday. The numbers that we have on file, we've attempted to call. This case is from 2023. So, like I said, listed him as homeless / unhoused. And we've been trying to get in touch with him. We also spoke to his bonds company. The number they said that they had was disconnected.
All right, and Deputy Laura, did you make an announcement?
Yes, Your Honor, I did. He is not out there.
All right, state.
Forfeit bond, issue warrant.
All right, what the court will do, normally the court would issue a bond forfeiture, but in this case, the court will issue a judge's warrant, remand him without bond. And the reason the court is doing that, because sometimes Odyssey people don't receive notice for their first setting. So I'll issue a judge's warrant and remand your client without bond. If your client makes an appearance, the court will reconsider.
Yes, sir.
All right, thank you.
May I be excused, Your Honor?
Yes.
I don't know where to call the judge. They have tendered an offer.
All right, thank you.
Okay.
Diana Belmaris. Elon Gonzalez. Rico Silva, I know, just have a seat. I know that attorney is still working on that. And whenever you all are ready on Sydney Peterson, let the court know. Jason Guerra. And for attorneys who are waiting, those are the only files that the court has before it. So if I haven't called your name, it's because I don't have your file. Court is calling 2023 CR 9821A, State versus Jason Guerra. Can I have parties announced?
Megan Galloway for the state.
Danielle Cranbrook for the defense.
And are you Jason Guerra?
Yes, ma'am, I am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am, I did, Your Honor.
Are you the same Jason Jesus Guerra who was placed on deferred adjudication in 2023 CR 9821A for the offense of theft of property 2,500 to 30,000 on December 14, 2023 for a period of 4 years? Is that you?
Yes, ma'am.
State?
Violation of condition number 4 in Bear County, Texas. The defendant, Jason Jesus Guerra, did then and there fail to report to the supervision officer as directed for the months of October and November 2024 in violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor.
We waive the damages.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Your Honor. So the state's recommendation is that the court deny the motion and alter and amend the defendant's conditions to include a 30-day jail sanction in the Bear County Jail, a new TAP evaluation to be assessed in custody. And then we would also join in probation's recommendation to add the conditions for job readiness, oral recognition therapy, and weekly reporting for 90 days upon release from the Bear County.
All right, state, you may be excused. All right, what have you done on probation? You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Jason Jesus Guerra.
All right, what have you done on probation?
I've done lifetime recovery. I've done inpatient, outpatient. I've gave negative UAs when I did comply to the drug testing. I failed to report on it because my probation officer threatened me saying that she was going to MTR me if I do not have my theft assessment. Right,
All right, so here's the thing. Don't do that with me in this court, and let me just tell you why. Because in this court, I always tell people, when you're on probation, if there's an issue, bring it up with your probation officer. If you feel as though they're not addressing it, you can always come to court.
Yes.
So you could have came to the court and said, hey, this is what's going on in my world.
Yes,
So
ma'am.
you may proceed.
Yes, ma'am. I just panicked and got scared and just didn't go report because I don't want to get violated MTR. After she told me she was going to MTR me.
All right, any objection to the court review and the court summary?
No, Your Honor. It will verify that he has successfully completed the lifetime recovery and the outpatient treatment. He did have the classes pending and he hadn't been reporting for the last few months before the MTR,
Okay. Let's see.
but he did pass all the UAs that he had taken.
All right, Ms. Abrams, or sorry, do you have the court summary? For some reason, it didn't come through on my email.
Which sounds great.
All right, no problem. Thank you. Oh, no, no problem. All right, I'm gonna give you a choice. These are your choices.
Yes, ma'am.
If you would like, because I note that you've done some things and you successfully completed them. I note you successfully completed lifetime recovery. This is a state jail felony. 2 years more than 2 years have elapsed for this state jail felony. So I can revoke you and I will revoke you and I would send it to you under 1244 to 250 days. Or I can continue you. I'll follow the recommendation that your attorney has reached with the state for a jail sanction. And that jail sanction, I believe you all agreed to, was 30 days. And so you're gonna have to do that time day for day. And that will start today. So those are your two choices.
I would take a 30-day sanction.
Okay. All right, so this is what the court, and do you need to speak to your attorney about any of this or no?
No, miss, no, miss.
All right. So the court will find violation of condition number 4 true. The court will alter and amend conditions, deny the motion, alter and amend conditions to include a TAP evaluation in custody. There's to be a 30-day jail sanction. And the sanction begins today. And the MRT, I don't think that's needed, so I'm not going to order the MRT, but you need to have employment.
Yes,
And probation, that employment, again, there's to be no employment as a home healthcare provider or with minors. And you're going to need to have employment within 30 days of release from custody. Do you understand?
yes, ma'am, I do.
And then Ms. Abrams, we're going to do 90 sober support meetings in 90 days. Yes. And counsel, if there are some issues with the recommendations, for example, if they recommend inpatient treatment, you can always come back and we can address that.
Thank you, Judge.
All right, is there anything else you need from the court to
No,
be
ma'am.
successful?
No, ma'am.
All right, so I'm going to tell you again. If there's an issue, let your probation officer know. If you feel as though they're not addressing it, you can always come to court. You understand?
Yes,
All
ma'am.
right, thank you.
Thank you, ma'am.
You're welcome. And if you could give that to Ms. Abrams, please.
I got one in the CIE and then else. Thank you. Thank you.
I don't think there's an issue with it.
The box.
Who is here on Timothy Evans? All right, come forward. Are you all ready to proceed on the motion?
We've reached an agreement.
Okay.
Parties have engaged in discussion. I think we're all on the same page.
All right, court is calling 2019 CR 8714 State versus Timothy Allen Evans Jr. Could I have parties announce?
State.
Joey Contreras for the defense.
All right, and are you Mr. Evans?
Yes.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it? Are you, yes.
I don't mean to interrupt, but
Oh, why didn't they tell me this
I
beforehand?
don't know. She
Sorry,
needs to
it-
sign it. Sorry, Ash.
But Sean, if you know what, I'm gonna bring my crystal ball that I do not have. and read mine.
Oh, sorry.
All right. All right, so Mr. Evans, let me explain something to you. I'm signing the motion to withdraw. I have reviewed the allegations that are in the motion. So don't know if it's true or not because they withdrawn the motion. But let me just tell you, people will always say, I can't believe somebody went to prison for smoking marijuana. And they don't realize that the person is on deferred adjudication.
Yes.
So let me just tell you, with what you're charged with, and I know your attorney has probably told you, you're looking at 20 years in prison. I know sometimes people think marijuana, alcohol, sometimes it's legal. What's the big to do? But according to the rules of probation, you're not allowed to do that. You understand? So do better. If there's an issue, speak to your probation. If you feel as though you can't stop doing it on your own while you're on probation, speak to probation. We'll see what we can do. You understand? All right, good luck to you. Thank you for dressing appropriately for court.
Thank you, Judge.
Thank you.
I'll get started.
Judge, can we reapproach on Mr. Evans?
Yes.
I believe the state agreed to the withdrawal with some amended conditions.
Okay, Mr. Evans, if you'll come forward, please.
Sorry.
Yeah, no, it's okay.
That's why we have you.
Judge, the amended conditions that the probation department is seeking is intensive outpatient treatment, sober support meetings, and weekly UAs.
All right, so with regards to the weekly UAs, I will alter and amend to include weekly UAs and test for levels.
Thank you, Judge.
All right, here's the thing. And we're not on the record. Are you able to stop using marijuana?
I have already.
All right, so is there any other thing other than the marijuana that's going on?
No, just marijuana.
All right, so this is what I'm going to do. I'm going to give you a choice. You can either do intensive outpatient treatment or you can do sober meetings, 120 and 120 days. But here's the thing with that. If you come back to me with a violation of marijuana, don't come back to me and say, well, I needed intensive outpatient treatment and you didn't give it to me. So you can choose one or I can order both.
It would depend on, I guess, which one makes with my schedule.
Sober support meetings would probably work better with your schedule because I'm saying 120 and 120 days. You can do a sober support meeting. There's one available 24/7.
Oh, okay. Yes, ma'am.
Intensive outpatient treatment, there's a schedule for that.
Okay.
All right, Ms. Abrams, and it's going to be 120 sober meetings in 120 days. All right, thank you.
Thank you.
You're welcome.
Thank you, Judge.
You're welcome. Have a good one.
Does this indictment have enhancements? Thank you. Sorry about it. I should.
Who is here on Beverly Ramos? Good morning. Where's your client?
Yes.
Come forward.
I'm filling in for Tim Roundtree today.
All right. State on this case, were you able to tender an offer and defense? Do you have all discovery?
Yes, Your Honor, they tendered an offer to us. As for the discovery, I believe we have everything. I'm not the attorney of record, so I don't know for sure, but from my understanding, Tim Roundtree does have all the discovery.
All right, so I'm going to give you a plea deadline date. Ms. Fergus, can you set this for a plea deadline date, April 24th? All right, your plea deadline date is going to be April 24th. At that time, you need to let the court know whether you've reached an agreement with the state. If you all have not reached an agreement, your next court date is going to be a jury trial date. Do you understand?
Yes, ma'am.
All right, and thank you for dressing appropriately for court.
Yes, ma'am.
All right, once you sign the reset form, you'll be excused.
Thank you, Your Honor.
Thank you. Jose Velasquez Jr.
Morning again, Your Honor.
Good morning. Hello. All right, so on this case, counsel, have you received all discovery?
I believe he has, Your Honor. On this case, Tim asked me to get a plea setting for either April 21st, 23rd, or 25th.
It's going to be April 24th. That's what the previous case is set for.
I'm not sure that he's available on the 24th, Your Honor.
Well, I just gave you a reset form for the 24th for his previous client.
I think on the other one, I think he's probably gonna try to have someone fill in for him again.
All right, so when is he available?
The 21st, 23rd, or 25th of that week.
All right, Ms. Ferguson. On Beverly Ramos, change that date to April 21st for plea deadline date. And then Velasquez will be April 21st for plea deadline date.
Thank you, Your Honor.
All right, thank you. Thank you for dressing appropriately for court.
Have a good day, Your Honor.
You too. Who's here? And Cynthia Deano.
Good morning, Your Honor.
Good morning. So where are we on discovery? Yes.
So we just received CPS records. We're going to just show those over to defense after that is signed and have a prayer to make a copy for defense and turn it over to them as soon as possible.
All right, thank you.
Then I do need to file a separate discovery motion. I know there's some other discovery that's available from the apartment complex, some videos and some different things that we do need to request.
All right, Ms. Ferguson, I need a 30-day reset for discovery on Deano.
Thank you.
Oh, I think May 8th.
All right, May 8th.
Yes,
Thank you so much for dressing appropriately for court. Once you sign the reset form, you are excused.
Thank you, Your Honor.
You're welcome. Javier Salazar. Court is calling 2025 CR 0014556 State versus Javier Salazar. Could I have parties announced for the record for the state?
Andrew Barrett, Stadelman.
Larry Meadows for the defendant.
And are you Mr. Salazar?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I have. Yes, we have.
Court will find that the state is in compliance with discovery. Mr. Salazar, did you review the application for community supervision with your attorney? Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
No, Your Honor, waiving the individual offender against an allegation.
Any objections?
No objection.
Mr. Salazar, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with evading arrest, detention with a vehicle. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
he does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, both, Judge.
Mr. Salazar, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand that?
Yes, ma'am.
According to the plea, punishments be assessed at 10 years in the prison. The state recommends community supervision. This will run concurrent with County Court Cause number 732238. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes,
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
no,
Outside the agreement, the state is recommending that your community supervision be for a term of 10 years. Did you understand that that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State in Exhibit 1 and attachments, Judge.
no objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulations of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, well,
Anything you wish to say on behalf of your client?
no, Your Honor.
Anything you wish to say?
No, ma'am.
How old are you?
I'm 35.
Why are you doing this fully? She could have been killed. An officer could have been killed. A citizen could have been killed because that's happened when there's people who don't pull over when the police ask them to pull over.
Yes, ma'am. It was foolish of me
Mhm.
foolish of me to do or commit.
So are you employed?
Yes, ma'am.
What do you do?
I have my own company of construction.
All right. Do you have any children?
Yes, ma'am.
All right. See, and how old are your children?
13, 15, and 16.
All right. So you have a 16-year-old who maybe is going to start driving. And what I can tell you, 16-year-olds, when they start driving, they really don't have the experience yet. So this chase that you were doing or this evading with this officer, that could have been your 16-year-old out driving on the road, not knowing what to do and getting hit, maybe being killed because you're out there evading. You understand?
Yes, ma'am.
All right, this is what the court is going to do. The court is going to sentence you to 10 years in the prison, suspended and probated for 8 years. Regular reporting by Zoom or in person. Regular random UAs. Defensive driving course. Proof of employment within 30 days. No employment as a home healthcare provider or with minors. 100 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. Field visits 1 time per month for 3 months. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing in this court, when you're placed on probation, if there's an issue, let your probation officer know. If you feel as though they're not addressing your issue, you can always come to the court. And if I am here, I will see what we can do for you. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
And Judge, so you reduced it to 8 years probation?
All right. All right, just remain in the
Thank you.
court probation. We'll go over conditions.
Thank you, ma'am.
You're welcome. Who's here on Joseph Grant?
I am, Your Honor.
You know, I said today had a feel like Monday and it has turned into a Monday. What can you do? All right, where's Mr. Grant? Hello. All right. All right, I know you've been recently appointed.
Correct.
And so do you need a reset for discovery?
I do, Judge, just to let the court know. I know the charges don't look that serious to the court, but there's a lot more to this case than meets the eye. I need to have a meeting with Mr. Garrett, and I've already talked to Megan about what's going on, but
All right, well, they're currently in a murder trial. So what I'm going to do is, and I normally don't do this, but this is an attorney who's recently been appointed. I'm going to give you a 45-day reset for discovery.
thank you, Judge.
Ms. Ferguson, I need a 45-day reset for discovery. Thank you for dressing appropriately for court, but you always do. I appreciate that.
Thank you, Judge.
All right, Mr. Porter, does May 19th work for you?
That sounds good, Judge.
All right. We will see you back on May 19th. Roxana Gomez. And Miss Gomez, if you'll come up. Is she here? Yes. Come forward. All right, on this case, was her warrant lifted?
Judge, she was in custody yesterday, but as of yesterday to today, she got released.
All right. I just wanted to make sure there wasn't an outstanding warrant. All right, so where are we on discovery?
Okay, well, we've got all the old discovery. We've actually been made an offer and she's agreed to accept it. The problem is we don't really have time this morning. I gotta be in another court too. So I was wondering if we could come back maybe next week or something.
All right. I can bring you back tomorrow.
Tomorrow? Yeah, we can do it tomorrow.
All right, Ms. Ferguson? Recall this case for tomorrow for disposition. And state, if you'll have the paperwork ready on Roxana Gomez.
Yes, Judge.
Thank you.
Oh, thank you.
Once you sign the reset form, you're excused. And thank you for dressing appropriately for court.
Thank you.
Rico Silva. Are you ready on Mr. Silva or no?
I'm still confirming Megan.
Okay, I'll let you just approach whenever you're ready.
Thank you, Judge.
Melvina Kane. Who's here on Melvina Kane?
Ms. Kane?
All right, are you all ready to proceed on this motion?
Yes, Judge.
All right, court is calling 2023 CR 6685 State versus Melvina Kane. Can I have parties announce?
Andrew Harris, Salem for the state.
Danielle Cranberg for the defense.
Oh, okay, thank you. All right, and what are you all asking for with this motion to withdraw?
DDRF and NIC evaluation.
All right, so let me see here. All right, the state is asking that the motion be withdrawn. I'm going to withdraw the motion, but they're going to want you to do a MIC evaluation to see if you are appropriate for DDRF. If not, then to see if you're appropriate for the MIC caseload. It's really designed to make sure that your mental health issues, if there are any, that they're taken care of. All right. All right. Is there anything else you need from the court? All right. Thank you.
Thank you, Judge.
You're welcome. And yeah, that's to be done in custody. You're welcome. Court is calling 2024 CR 010488 State versus Moses Wamuyu. Could I have parties announce?
Megan Galloway for the state.
Joseph Dateson for Moses Wamuyu.
And are you Mr. Wamuyu?
Yes, yes.
Counsel, have you received all discovery?
Yes, Your Honor.
Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Wamuyu, did you review application for community supervision with your attorney? Did you understand it and sign it?
Yes, sir.
All right, everyone on this end, if you could move down to that end. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? Counsel. Are you proceeding on the indictment as presented?
Yes, Judge.
No problem. All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with driving while intoxicated, third or more? That's a third-degree felony. Range of punishment is anywhere from 3 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you were giving up those rights. Did you intend to enter into this plea and give up those rights?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Wamuyu, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Judge.
Anyone promised you anything other than the plea?
No, Judge.
Are you satisfied with the way you've been represented?
Yes, I am.
Are you a U.S. citizen?
No.
Counsel, did you have a Padilla letter or an attorney consult with him on his immigration status and the impact this plea will have on that status?
Yes, Your Honor. I had requested an immigration attorney be appointed. The court appointed Teresa Coles Davila. She interviewed him. She prepared the Padilla letter. Went over the Padilla letter with him. We read it together. I admonished him. I advised him of the immigration consequences. Knowing this, he still wishes to go forward with his plea today.
All right. Do you understand by entering this plea bargain agreement, you can be deported and not allowed re-entry into the United States?
Okay.
Do you understand that you could be denied naturalization?
Okay.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, punishment is to be assessed at 6 years in the prison. There's a $1,000 fine. State recommends community supervision. They're taking in consideration 2024 CR 010467. There's to be restitution of $700 to Anthony Hall Jr., admission interlock for half the term. Did you understand that to be the plea?
Yes, sir.
Defense, is that the plea?
Yes, Your Honor, and
State-
has something to add at the appropriate time.
All right, state, is that the plea?
It is.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes.
Did you sign it in both places?
Yes, sir.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years, that there be 10 days in the Bexar County Jail as a condition. Community service hours, no contact with Anthony Hall Jr., DWI intervention, and VIP. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, sir.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offers 3-1 in attachments.
No objection.
States, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Did you understand again that you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony?
Yes, sir.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge. We asked that he follow the agreement. Also, he currently does not have a vehicle. He Ubered here today. He's going to continue to do Uber until he gets a vehicle back. His vehicle is disabled. It's not running. And I admonished him that although he can request a portable alcohol monitor device, that if he does obtain a vehicle, he must contact his probation officer and substitute it. He cannot drive without ignition interlock. Further, he's been in Bexar County Jail approximately 7 months. He's asking if he could have credit for the time he served for the 10 days. And if not, if there could be a Bear Gives Back program where he can volunteer his time to avoid the 10-day sanction. Also, I'm appointed. He's had a considerable amount of time where he was not working, hoping that perhaps he could probate part of his fine.
And are you currently on GPS?
Yes, I am.
All right, this is what the court is going to do. The court is finding you guilty. The court will sentence you to 6 years in the prison, suspended and probated for 4 years. There's $1,000 fine that will be probated. Take in consideration 2024 CR 010467. There's to be no contact and restitution of $700 to Anthony Hall Jr. There's to be ignition interlock for half the term, or there's to be alcohol monitoring device with an affidavit of non-driving for half the term. DWI intervention course, VIP live, DWI education course, regular reporting by Zoom or in person, proof of employment within 30 days, no employment as a home health care provider or with minors, TAP evaluation out of custody, follow all recommendations of TAP. There's going to be 10 days GPS in lieu of 10 days in the Bexar County Jail, waive fees. And the court will note for the record that the defendant is currently on GPS. There's to be 100 hours of community service restitution. Do you have any children?
No.
All right. There is to be 90 sober meetings in 90 days. Probation, is there anything else?
No, Judge, can you clarify the GPS? I heard 10 days GPS in lieu of 10 days for county jail.
Yes.
Cool.
Yes.
Bill visits, Judge.
Thank you. Field visits 1 time per month for 6 months. All right, is there anything else you need from the court in order to be successful?
No, Judge.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is a plea bargain agreement, because it's your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I understand.
All right, we can go off the record. Here's the thing. I have yet to meet anybody who ever says, my intention is to go out, drink, and kill somebody. But you know what ends up happening? People get intoxicated. They don't think they're intoxicated. And this could have turned out so much differently. You could have killed someone. You understand? So you're one of those people. If you didn't know before, I'm going to tell you, you're one of those people who cannot drink at all. And while you're on probation, you're not allowed to drink alcohol. Those are the rules. You understand?
Yes, I do.
All right. If you ever need anything, let your probation officer know. If you feel as though they're not addressing it, you can always come back to the court. All right. Thank you.
Thank you, Judge.
You're welcome. You ready on Mr. Silva?
Yes, thank you.
Rico Silva? You need something? Okay, and then if you could give them back, because I haven't put them in the system. Hopefully you can read my writing. Deputy Lawyer, you don't need to bring anybody else out. All right, on Mr. Silva, so it's the court's understanding that you wanted a different attorney, so a new attorney has been appointed to you. All right, and counsel, I know you've just been appointed.
Yes,
Do you
Judge.
need another discovery date?
Discovery reset, and I don't anticipate this to be 30 days. If there's something sooner prior to 30 days.
All right, if you want, I can set it the week of April 14th.
Let me check. I'll be here April 14th.
All right, Ms. Ferguson, if you'll recall this for April 14th. All right, we'll see you back then. You're
you, Judge.
welcome. Patrick Washington? Mr. Washington?
Yes, we need to get this case set for trial.
I don't know anything that the two of you discussed.
Hi, Mr. Washington. Mr. Washington, come forward. Hi. Hi. So, defense, do you have all discovery?
As far as I know of at this point in time, Judge,
And was an offer tendered?
there was an offer.
All right, Mr. Washington, I can do one or two things. I can set you for trial, or I can bring you back. That way you'll have a time to think about the offer that has been tendered. Do you want a jury trial setting? Or
Yes, ma'am.
all right, so that means that your plea deadline date will have expired. So if you decide to enter into a plea bargaining agreement, the court will not accept plea bargaining agreements without good cause. Otherwise, you have to plea open to the court. Do you understand?
Yes, ma'am.
All right. How long?
Is that still apply if they make a different plea offer?
Yes.
Okay.
All right. So, Ms. Ferguson, this trial should probably last 3 days, and that includes jury selection.
August 5th?
I'm sorry, what?
August 5th?
No. You got a June date, July date? What's good for you, counsel?
I can look at my. Let me look at my.
What the earliest?
All right, do y'all think you'll be ready for jury trial the week of April 21st on this or no?
I know the answer.
I believe we'll be ready.
Hey, Megan, on this case, the defendant wants his jury trial as early as possible. I don't know if you all would be ready the week of April 21st on this. It's the ag assault. Or would you all be ready sometime in May? May? All right, is it your week, the week of May 19th or no?
Yes.
All right, so what I can do, sir, there are no guarantees because there are other cases that have been set. And so usually we go in order of the oldest case, but the earliest I can put you down, I will put you down for May 20th and we'll see where we are. And that's the earliest I can give you.
You understand?
Yes, sir.
All right, so we'll come back for jury trial on your case, May 20th.
Thank you very much.
All right,
Make
thank
me
you.
excuse.
Yes.
Thank you. Okay, Mr. Washington, I'll be in touch with you. Okay, I'll set up the meeting. Right.
She had called it right, the guy had to see it.
What page is Washington on?
Elon Gonzalez.
Michael Faz? Good morning. All right, where are you all on discovery?
We are good on discovery. He does not want an offer at this time. He would like a jury trial.
All right, state you'll need to tender an offer to him, and I'm gonna set this for a plea deadline date.
Washington.
Ms. Ferguson, recall this back on April 10th. Are you available April 10th?
Yes, Your Honor.
April 10th is gonna be your plea deadline date, and if an agreement is not reached at that time, I'll give you a jury setting. So state if you'll give him an offer, please. All right, thank you.
Thank you, Judge.
Oh, he needs to get his offer.
Okay.
Elon Gonzalez. Hello. All right, so is he doing PTD still?
Yes,
How's it going?
it is good. We've gotten a signed contract back from the state. We've both signed that and it's been tendered back to the state, and Mr. Gonzalez is going to report in either today or probably.
All right, so Ms. Ferguson, I need a 30-day reset for PTD. All right, May 8th.
May, it's fine, Judge.
All right, thank you for dressing appropriately for court. All right, once you sign the reset form, you're excused. Diana Belmaris. Diana Belmaris.
Actually, the house, go, and I haven't been able to find her, so I was gonna try to get her bond. I was in Richard Falls, we were really talking for something, approach, Norma, maybe to do that.
All right.
I can bring her in this morning, we'll take her out of time on that.
Oh, no, you can approach and get the bond information. Sydney Peterson, are you all ready? Okay. Oh, okay, all right. All right. All right, Deputy Laura.
Yes, Your Honor.
Mañana is coming back tomorrow.
Okay.
Who is here on Sarah Brown? Good morning. So where is she?
Well, Judge, I don't believe she's here and that's my fault. I was out last week and I was just looking when Sarah notified me to be here this morning. I just saw her letter she sent me on March 25th.
Okay, so what I'm gonna do is I'm gonna recall it for tomorrow. She'll need to be here.
Is there any possibility to do it on Monday? I have to be in Hondo tomorrow.
Okay. I mean, you can appear by Zoom. The reason why it's being set is because of the violation report. And so I really can't have violations report sitting out there. So if you want to appear by Zoom, you can just make sure she's here so we can address this and make sure we can get her into compliance.
Okay.
All right, thank
Thanks,
you.
Judge.
Norma, Sarah Ashley Brown is coming back tomorrow. Ryan Westbrook.
Good morning, Your Honor. I'm here.
Good morning. Hi, where's Mr. Westbrook?
He is not present in court at the moment, Judge, but I have talked to the state about this. This is what we're approaching the court on. Mr. Edelman,
State requests that this case be recalled tomorrow and that it not issued at this time. We believe that there may be sensitive negotiations.
All right, so we'll recall it for tomorrow.
thank you, Your Honor.
All right, thank you.
We have two others as well. I think that's on here, this one over here.
All right. Leon Small?
Your Honor, this is one that we were brought back on, I think from about a week or two ago.
Mhm.
He is in federal custody.
Yes.
We had filed a motion on a bond motion on this particular case. However, this morning, he is actually set for his detention hearing in federal court. I think he's actually in it as we speak. Depending on how that goes, I think it's going to dictate what the state may do and what it potentially resolution and what we'll definitely do on that if it's not resolved.
Do you want it recalled?
I would ask probably for a week, Judge. I think that would give us enough time to find out.
All right, Norma, on Small, recall it for April 10th.
Thank you, Judge.
All right, thank you.
And then one last one, Your Honor, that's yet another federal case.
Who is that?
That's Fernando Trujillo.
I don't have that up here.
Okay, sorry about that.
So just give me a moment. Once that's put up here, I'll take it up. Who's here on Alfred Robago?
Ready, Your Honor, all please.
Court is calling 2025 CR 0023886 State versus Alfred Robago. Robago. Could I have parties announced for the record? State.
Andrew Harris,
Defense.
Nando Ramos for the defendant.
And are you Mr. Robago? Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Robago, did you review application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented? Mr. Robago, did you review the court admonishments, counsel? Counsel? Did you review the court admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places? You're charged with the offense of possession of a controlled substance, penalty group 1 to 4 grams. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you were giving up those rights. Did you understand?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yeah, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Robago, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 4 years in the prison. The state recommends community supervision. They're taking it in consideration 2024 CR 012753. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Do you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
None, Your Honor.
Then to the offenses charged, I'm sorry, and outside the agreement, the state is recommending 4 years for your community supervision term. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence.
It's in exhibit 1 and attachments, Judge.
No objection, Your Honor.
State you may be excused.
Yes, Judge.
Did you review the document entitled admonishments with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and the attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
We waive our right to a PSI and wish to be sentenced today, Your Honor.
Anything you wish to say on behalf of your client?
My client has a common law wife with children and wishes to go back to work, and we plead that you follow the plea bargain, Your Honor.
How many children do you have, sir?
I have one. She's 35 years old.
All right, and this person that you say is your common law wife, how many children does she have?
She's, come on, we don't have any kids, but my other girlfriend I have a daughter with her. But my common law wife, myself, like stage 4 cancer, I met her 5 years ago.
All right, so which gang affiliation do you claim?
Me?
Yes.
I was the admin.
Okay. All right, this is what the court is going to do. There's going to be 4 years in the prison, suspended and probated for 4 years. Regular reporting, Zoom or in person. TAP evaluation in custody. Follow TAP recommendations. 90 sober meetings in 90 days. Gang supervision. Proof of employment within 30 days of release. No employment as a home health care provider or with minors. There's to be no contact with minors. No residence with minors. 200 hours of community service restitution and probation. I'm assuming that the gang supervision will take care of field visitation.
Yes, Judge.
All right, probation, is there anything else he needs?
Judge, I'm sorry, did you say regular random anyway?
Thank you. Regular random UAs.
Nothing else, Judge.
Is there anything else you need from the court in order to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. Stay in contact with probation.
All right, thank you.
Thank you.
Have your excuse, Your Honor.
Yes.
Thank you, Judge.
Sydney Peterson, are you all ready? All right, and after this, Deputy Laura, anyone else, they'll need to come back in the afternoon. And I know I have one case. I'm just waiting for them to put your case up for the reset.
Talking to me, Your Honor?
Huh?
Or you said-
Oh, no, it was another attorney behind you. All right, the court is calling 2023 CR 1041 State versus Sydney Lee Peterson. Can I have parties re-announced for the record for the state?
Ashley Jones.
Defense?
Gary Chirek.
And you're Mr. Peterson.
Yes, ma'am.
All right, on March 18th, you entered a plea of true to violation of condition number 2. The court found that violation of condition number 2 was true. State waived all other allegations. And so it was recalled for today for one, as defense counsel said, for me to consider things because you appear to be young. And because the violation of condition number 2 is not submitting to drug testing, which tells me that there are drug issues. And also for both parties, if they have witnesses, to call witnesses. but it's the court's understanding that you all have reached an agreement.
We have, Your Honor, and that includes a case that will run concurrently.
Okay.
Yes, ma'am.
That, would you like the?
Yes, what is the
Okay,
agreement?
The
Yeah.
agreement is for the court, so agrees to grant the state's MTR and adjudicate him guilty and sentence him to 5 years in the Texas Department of Corrections to run concurrently with the burglary of a habitation case.
And what is that cost number?
It is a waiver number, Your Honor.
Yes.
Would it be- Well, do you have that?
Yes.
No problem. Oh, do you have a stamp? Has he been sworn in?
Not on this.
Okay. All right, so this is to run concurrent with 2025 CR 004119W, is that correct?
That is correct.
All right, are you asking the court to follow that agreement?
We are, Your Honor.
And sir, are you asking the court to follow that agreement?
Yes, ma'am.
Okay, let me see if I have a trial court certification in here. All right, counsel, if you could get a trial court certification, for some reason, it's not in here for this.
MTR, I thought we did one
Yes.
last time we were here.
Sometimes paperwork goes missing. So if you could, it was stapled to another form. Thank you. All right, you're asking the court to follow this agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yeah, yes, ma'am.
All right, then what the court will do is the court will follow your agreement. The court, as previously stated, found violation of condition number 2 true. The court will sentence you to 5 years in the prison. This run concurrent with 2025 CR 004119W. There's a $500 fine, time, and money to run concurrently. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, Your Honor.
Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, thank you.
Judge, can I swear a member of the?
Yes.
Yes, ma'am.
Raise your hand.
Anyone?
Are you Sidney D. Peterson, defending case number 25 CR 004119?
Yes, ma'am.
Are you familiar with the exhibits attached here to and so on and so on? Is correct to the best of your knowledge?
Yes, ma'am. Yes, ma'am. Yes, ma'am.
Are you familiar with this document?
Yes, ma'am.
And so turns on with your constitutional rights and December.
Yes.
And it's your desire into this plea and waive your right to jury trial. Okay, this is just an instrument. Here.
Right.
And on the page. Here. Okay. And
All right, we're going to go on the record in 2025 CR 004119W. Could I have parties announced for the record?
Ashley Jones for the state.
Gary Chirek for the defendant.
And are you Mr. Peterson?
Yes, ma'am.
Again, counsel, in this case, have you received all discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Peterson, did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney? Did you understand it and sign it?
Correct.
Do you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to hold you over for trial?
Yes, ma'am.
And do you understand that your attorney has certain rights? Namely, he has a right for the passage of 2 days from the presentation of the information and 10 days to prepare for trial?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information, and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Counsel, do you waive the reading of the
We do,
felony
Your Honor.
information? And you reviewed the felony information with your attorney?
Correct.
You understand it?
Yes, ma'am.
State you're proceeding on the information as presented. Mr. Peterson, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with burglary of a habitation. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you were giving up those rights. Did you understand?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Your Honor.
Mr. Peterson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's to be a sentence of 5 years in the prison. There's a $1,500 fine. This is to run concurrently with 2023 CR 1041. There's to be no contact with Estefany Ruiz, Lisette,
Maria.
yes, Mardiaga. That's Maradiaga. And also no contact with Roberto Mardiaga. Can't roll my R's.
It's okay. It's new to me too.
All right. And is this a family violence finding or no?
No, Your Honor, it's actually not as by offense.
I have a.
All right.
Additionally,
And actually, Judge, on the Ruiz, the first thing is supposed to be no harmful and
Yes.
injurious.
For Estefany Ruiz, that's supposed to be a no harmful or injurious contact order,
Yeah,
and a
that
no
should-
contact order for.
So, in other words, no harmful and
Lisette and
injurious, so you can have contact with her as long as you don't fight her.
Yes.
All right?
Thank you. I have kids with it.
Did you understand that to be the plea?
Yes, ma'am.
Defense is that the plea?
It is, Your Honor.
State is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal?
Yes,
The
ma'am.
only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There are none, Your Honor.
Then to the offense is charged. How do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers State Exhibit 1 and all attachments.
No objection.
Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Correct.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments, and the court will review the same. So, court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Here's the court's question. So, Estefany Ruiz, are these other two people her parents or?
Your Honor, the relationship is, Estefany is Lizette's husband's cousin. and they were dating.
Excuse me? You said Lizette's husband? Lisette is, Roberto is, yeah, the husband, you said. A cousin, that's the cousin.
Yeah.
All right, and does she want to have contact with him?
She sent me a letter.
Well, no,
No.
here's the thing. Let me just explain this something. Sometimes absence makes the heart go fonder, and sometimes it's just like, they're in jail. Let me throw them a bone and write them a letter. So I'm trying to figure out if that's the case.
Yes, ma'am.
And Your Honor, we spoke with both Lizette and Lizette spoke with Estefani in our presence, and Estefani would like contact because they do share a child. Lizette and Roberto do not want contact.
All right. So the court then will follow your agreement, find you guilty, sentence you to 5 years in the prison, give you credit for any time served. This will run concurrent with 2023 CR 1041, $1,500 fine, time and money run concurrent, no contact with Lizette Madriaga or Roberto Madriaga, and no harmful or injurious contact with Estefani Ruiz. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is plea bargaining agreement, because I followed your plea bargaining agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing, Estefania, maybe she wants to be with you now, but sometimes when people are in prison, guess what? People meet new people.
Yes, ma'am.
So if she meets somebody new, guess what? That's all on you because you're the reason you're in prison, not her.
Yes,
You need to let that go
yes, ma'am.
and be a better parent for your child.
Yes, ma'am.
All right, good luck to you.
Thank you, Your Honor.
You're welcome. Last case, sir, who do you have? Yes.
Fernando Trujillo, Your Honor.
All right, do you have the file on Trujillo?
It was put the other one. It's file some of that.
Yes. Yes.
Taylor, I presented the wrong forms for the.
Okay. All right, so Mr.
Thank you, Judge.
Trujillo.
He is also in federal custody, Your Honor. My understanding is that he's been in there for a little while now. But the court is that if you can just give us a little bit of time, Judge, a matter of 3 weeks or so, I can find out where that's heading, give the court an update and see if maybe that'll help. Get us
All right, and everyone, the court is on recess. All right, let me see. Trujillo. What page is Trujillo on? All right, so counsel, do you want this called back when?
Probably something in the realm of like 3 weeks, Judge. I think that's probably the closest amount of time where I can get everything done.
So I can put you for May 5th.
That sounds great, Judge.
All right, Trujillo is May 5th.
Thank you for your time, Your Honor. Really.
All right. Anything else?
There you go.
Yes.
Thank you, Judge.
Thank you.